Good evening. My name is Ryan Burrows, Executive Director of the American Kratom Association. Thank you for making the time to join us this evening. We met just a few weeks ago, and the latest information has changed just that much that we needed to call this meeting this evening. The invitation tonight states we don't want to be alarmists, and we don't, but some critical updates have taken place since we met last with respect to kratom criminalization, and on a state level in particular in Rhode Island and Nevada. And we want to provide clarity on Louisiana and, of course, give you the updates in other states, including Arkansas. We can't get tired and let fatigue set in. We truly need your continued help. The QA is open, and I will now turn it over to Mac Haddo, our Senior Fellow on Public Policy.
Thank you, Ryan, and thanks to everyone who's joining us this evening. We truly appreciate your joining us. And for those that are able to watch this later, that weren't able to join us this evening, welcome as well. You're obviously welcome to put any questions in the chat, and we'll try to get to them as we go through this webinar this evening. The first thing I wanted to address is an issue that obviously is really at the fundamental core of what we're fighting about, because we all know that the battle that we took on in 2016 was to stop a ban on kratom. And one of the issues that arose in the context of that fight that we took on with the FDA and took it to the DEA to expose the weakness of the arguments and the scientific evidence that the FDA had provided, which we have done routinely since, but including in that fight in 2016, was the letter that Senator Cory Booker from New Jersey sent along with a couple of his colleagues, Ron Wyden and Senator Gillibrand. And in that letter, he talked about the failure of the drug policy that the United States had embarked on, where you criminalize people and you put them literally into jail, and you fill prisons with people that have simply are guilty of struggling with some of the addictions that they have and really don't deserve that kind of treatment. But it is inevitable that when you impose a Schedule I designation on any substance, and in this case, including kratom, where it is particularly egregious because kratom is not at a federal level a Schedule I substance. And the reason it's not is that it is not schedulable, does not meet the criteria that is established by both the Federal Controlled Substances Act and by the state statutes that mirror the criteria for scheduling at the federal level. So when we see the disappointing results of those states that choose to schedule kratom, and you see the horrible, horrific kinds of outcomes. We saw it in in Arkansas, where you had the Marshall Price case, where he not only was subject to a wrongful conviction because he was attempting to use kratom and had proven that kratom had helped him with his addictions, and it was saving his life, and he ended up being incarcerated, and unfortunately and tragically lost his life while incarcerated. And he never, ever would have been in that situation but for the short-sighted policy view that was adopted by the Department of Health in the state of Arkansas. And we see that situation being replicated with the arrest of Shana Brown in Alabama. We're going to be doing all that we can to expose the folly, the absolute tragic outcomes that come when we criminalize people for the possession of a substance that's helping them. And the facts and circumstances around the Shana Brown case are particularly egregious. When you look at the fact that she had purchased kratom legally, and this is true at the Price case too in Arkansas, driven across the state line. In the Brown case, she didn't even understand or know that she was in the state of Georgia, Alabama, and was arrested at a traffic stop and thrown into jail. The great news is, for now, that she has secured her release with a family friend that apparently put up her home, or his or her home, in order to guarantee the bail that she needs in order to go free. And we know that was critical, according to the attorneys that are looking at this case, that she needed to become free so that they could get the case appropriately placed into the right level of the court system where they can hopefully get these charges dismissed. But even if they do that, it doesn't offset the obvious mistake that was made by the legislature in Alabama to enact a Schedule I ban driven by a group of I'll try to be as kind as I can, by prosecutors who simply were trying to enact a public policy that was inconsistent with the public interest, but only allowed them to thump their chests and act as though they were some great protectors of the public in preventing horrendous drug crimes, which of course don't apply in any way to Kratom. So the silver lining in this effort will be that the circumstances around the arrest and the incarceration and the potential threat of a 10 years to life prison sentence because of possession, which automatically becomes distribution of a product like Kratom, is simply illustrates how egregiously wrong that policy is. We will do everything we can in order to highlight that, to expose it, and to hopefully educate the legislators in the state of Alabama that they are wrong in this policy. We had great news today in the state of Arkansas. I just got told that she's not out yet. I got bad information. Apparently today she has a bond hearing on June the 27th. So hopefully she'll be out shortly, given that her bond has been secured. But thank you, Misty, for pointing that out. This battle will go on, and we're going to have to be supportive and helping, and everyone needs to look at the various opportunities they can to provide support financially, because obviously they're going to have to hire an attorney that can defend, and she cannot rely, nor can any of us rely on a public defender being the kind of quality of attorney that will deliver the results that Shayna deserves. The great news I referenced a second ago is that in the state of Arkansas, and this is an interesting situation in that the Arkansas legislature meets every other year. And so when the legislative session ended, they then commenced interim committee hearings, and the Joint Committee on Health and Public Welfare in the state of Arkansas this afternoon passed approved, I should say, the interim bill that calls for a repeal of the Arkansas Department of Health ban on Kratom, and would recommend the adoption of the Kratom Consumer Protection Act. We'll put it up on social media and on our website. You need to read that bill, because it is a damning indictment of what the Department of Health did and continues to do, because we made a petition, the same elements of the petition that we made to the state of Vermont, who subsequently on March 1st, after they received our petition, reviewed it and came to the right conclusion that Kratom was not schedulable under the criteria, the scientific criteria required by the 8 factors, which are the same factors that the Federal Controlled Substances Act provides. And the same elements of that are true in the Arkansas case. So we think that we're going to be successful in the end in Arkansas in overturning that ban. But it needs to be the correct public policy going forward to highlight the fact that criminalizing people is not the right public policy solution. Even our fiercest critics, I believe most of them agree, because I've heard the testimony of some of the family members who have been caught in the tragic circumstance of losing a loved one whom they believe died because of Kratom ingestion. And even they have said in a number of occasions in legislative hearings that they don't think that people should be criminalized for using Kratom. So in that area, we agree. What we don't agree on, obviously, is that there is no known toxic level of Kratom that has been identified, despite the best efforts of the scientists who are anti-Kratom to try to establish it. Even a published article by the NMS Labs people, Dr. Barry Logan, acknowledged that there is no level of toxicity that can be identified for Kratom, and that he recommends that medical examiners look at levels above a certain threshold, which have nothing to do with a scientific conclusion that caused the death, but only that it's a high level of Kratom that was ingested by that person, and that would give a more reasonable conclusion than if it's under that level. And we've already seen that many of the deaths that were attributed to Kratom ingestion were at those lower levels. So it kind of leaves those medical examiners out high and dry. who have been listening to the likes of NMS Labs, who preach the doctrine of saying that Kratom causes deaths. And of course, all of that is done at the behest of the FDA. At the bottom of this corrupt mess is the FDA, spreading their disinformation, spreading their misinformation about Kratom, influencing otherwise legitimate people that are working in the healthcare system, and incentivizing them to become the disciples of the FDA in spreading this horrendous disinformation. We're embarking on a new program that we're going to be looking for help from the Kratom advocacy community, where we push back and report on all of the false statements that are being made by the FDA today. It's pretty interesting that Dr. Califf, the current FDA commissioner, correctly points out that there have been significant issues throughout COVID where companies were making illegal therapeutic claims about products curing COVID or helping reduce symptoms of COVID, where there's no scientific evidence. He now has embarked on this full-throated campaign against this disinformation, has a website up, asks people to report these disinformation incidents, and he wants to go after them. He's expending the resources of the FDA in order to go after and prosecute those healthcare providers or product providers that are making these illegal therapeutic claims. Good on him. But what he's not doing, what the FDA is not doing, is responding to the more than 75 documented cases where we have reported Kratom manufacturers marketing their products using illegal therapeutic claims. 75 over the last 2.5 years, and not a single prosecution, not one. And yet the FDA has the resources to go into Kratom processors today and try to shut them down, and all over the import alert, which we know is also a statute that's been misapplied by the FDA because they couldn't get their way in scheduling Kratom under the criteria established by statute that they're required to meet. And because they couldn't do it, because their evidence, as Dr. Joie said, was disappointingly poor evidence and data and a failure to consider the overall public health, they act like a petulant child and they go out and use the import alert. And I have said before, and I'll say it again, they abuse the import alert authority that they have. So we're going to continue to work hard in this area also, and stay tuned for what we think will be a counter website where we're going to report the FDA for every bit of the disinformation that they're circulating about Kratom. It is not insignificant, by the way. If you look at the FDA website today, you can find under the Kratom section of the website a report by Dr. Scott Gottlieb where he declared in a press conference that Kratom is an opioid. It was wrong then, it's wrong today, and yet it's still part of the FDA website. Is there a better poster child for disinformation? Because any public policy official, any media reporter that goes to the FDA website and starts to look at and is searching for information about Kratom is going to see the lie that Scott Gottlieb told, that Kratom was an opioid, even though by chemistry it is not, by law it is not, and by plant genetics it is not. And for them to continue to allow that kind of disinformation to sit on their website and then speak out of the other fork of their tongue and say, oh, but they do not want any of the COVID manufacturers to be spreading disinformation. What a horrendous public health crisis that is. Well, guess what? When you mislead the American public about Kratom that is, with many, many documented instances, saving people's lives because they find their way out of those addictions that they're struggling with. And I get it. There's people that disagree with that, and I understand that, but the compelling scientific evidence and data that's there that documents that is what has led the National Institutes on Drug Abuse to invest more than $30 million of our money in research to that effect. And that research is now producing the results about the potential value that Kratom has as we move forward in this crisis that we're facing of overdose deaths in America. We can save lives. Now, is it possible that people can abuse Kratom? Of course. Is it possible that there needs to be strengthened regulations around Kratom that would require manufacturers to put labeling that will instruct people on the safe use of their Kratom product? Of course. That needs to be done, and we've been working hard at that. There's not a perfect solution to that yet, despite our best efforts. But a good part of the problem here is the FDA refuses to regulate kratom the way they should. They instead go on their quixotic view that they can ban kratom with a de facto import alert, rather than being able to comply with the evidential requirements that are embedded in the statute. They violate the law every day when they go out and spread their disinformation and fail to protect the American public with the kind of regulations on good manufacturing practices, on proper labeling, and making sure that people are not advertising with inappropriate and illegal therapeutic claims. And I say it again, more than 75 instances reported, documented, and not one single prosecution, not one. And they're out chasing around talking about disinformation in the COVID space. The time has come for a course correction. That course correction was provided by the United States Congress in 1994. As we all know, when the Deshay Act, the Dietary Supplement Health and Education Act, when the FDA was spreading the same kind of disinformation about dietary supplements and wanted to ban all dietary supplements. Today, it's a $100 billion industry. 80% of Americans use them for their health and well-being, and the FDA hates it. Now, they got guardrails slapped on them hard by the Congress with the Deshay Act, and we think that the same thing has to happen at the federal level with Kratom too. So big challenges, one that I think we're all going to be working hard on. Part of our challenge here is to show the FDA that they are wrong when it comes to their evaluation of Kratom not being in commerce prior to 1994. That was the grand compromise in the Deshay Act that was passed on October 15th of 94. And the fundamental premise of that policy is that if we can prove conventional use and commerce in the United States prior to that date, then we can be grandfathered in and not be required to go through the new dietary ingredient notification process that the FDA is the sole judge, jury, and executioner on, and they consistently deny any Kratom vendor the opportunity to have an NDIN registered with them. So that being the case, our goal is to try to find that. We are scouring the earth for it. We're seeing some great positive outcomes. I think we're going to be able to eventually prove that case and force the FDA to do what they should do, which is to properly regulate Kratom rather than continue on their crusade against Kratom. Some things that we wanted to cover, and we're going to open up the questions here in a minute. The things we wanted to cover were some of the activities that we've had in the states. The legislatures are a messy business because there are things that happen in legislative sessions that have nothing to do with the bills that we're trying to promote, particularly with the Kratom Consumer Protection Act, where there will be a lack of action or a defeat of a Kratom bill that has nothing to do with the merit of the bill themselves, but rather to do with other factors. In a couple of circumstances, we saw that today. We saw it clearly in the state of Tennessee, where this year we look to be on track for the Kratom Consumer Protection Act, and I have just learned that our problem had nothing to do with the Senate not accepting it, but rather an internal battle between two members of the legislature, where one of our sponsors was being punished because he sponsored a bill. And it didn't matter what the bill was. He was being punished by a member of the Senate in a powerful position because of an internal disagreement, which is now being played out in the Tennessee newspapers in a sordid story about this particular senator or the lieutenant governor that's involved in this with his Senate supporters. That's the kind of thing that we're struggling with in some of these situations. But we're not going to be deterred from continuing. We know that in the state of Missouri, we have a governor who is just hell-bent to block any Kratom Consumer Protection Act. It makes no sense, by the way, because he can't ban it in the state of Missouri. So the only option from a rational public policy standpoint would be to regulate it. And yet he vetoed the bill last year. And then this year, he signaled the Senate that he would veto it again without any basis other than he says that the FDA told him that Kratom is federally illegal. That is a lie. It's not true. And the FDA has no business saying that. So we will contend with that. I think eventually we're going to have to wait out this governor and wait for the next governor to come in. And so perhaps in Missouri, we won't get passage on the Kratom Consumer Protection Act in that state unless something dramatic changes. prior to the new governor taking office in 2025, when the current governor is term limited and won't be able to run. So we know that's a challenge. In some other states, it's all about trading off. Is it a priority for one part of the legislative body over another? And Kratom is just one of the bills that gets stuck into the commerce on that kind of thing. So commerce meaning the way they transact business in the legislatures. We saw that in Rhode Island. We got to the last days. We had it passed out of the House on a vote of 44 to 23. It was in the Senate. We had strong Senate sponsors, and then there was a fight that developed between the two legislative bodies, and they wanted a price for the passage of the KCPA. Had nothing to do with the KCPA, but they wanted another bill that was being held up in the House, and we became part of that bargain, which the price was too high. But we're continuing to have meetings in Rhode Island. We're going to file a petition, it looks like, with the Board of Health to challenge their scheduling based on Rhode Island law that allows for that to be filed. And it will probably do that in the fall, but we will be back in Rhode Island looking for passage next year. In the state of Georgia, we saw a ban that was advocated for by the trial attorneys. They were doing it to stage literally a PR campaign in order to go into court and say to the judge and the jury, well, look, even in Georgia, the legislature agrees with us, and they wanted to ban it. It was not good public policy. It was all about lining the pockets and gilding the lily in a lawsuit that ought to be tried on the merits of that case. Has nothing to do with what the legislature does or doesn't do. That was a cynical way to try to influence a jury pool in the state of Georgia. And thankfully, we defeated the ban, and we did negotiate finally a framework for a strengthened regulation. And I think that we will be successful in the upcoming legislative session to modify the current bill so that it's stronger in terms of regulations for, and this is important, to regulate kratom. And even our critics agree that regulation is better if they can't get their bans. And the bans have to be scientifically based, as we've talked about. In the state of Nevada, we had the governor veto the bill. He's a former cop. He had influence by the police departments in the state of Nevada, who are acting as surrogates and shills for the FDA. There's no legitimate basis for any law enforcement officer in this country to claim that kratom is a significant public safety threat. It is not. And yet they want to say that, and it's all because the FDA gins them up in order to do it. We also had the bill died in Illinois, mainly because legislators wanted more information, and we're going to see, and we'll come back to that. I know in Kansas, the same thing happened. We got right to the brink, and there was a little bit of discussion and negotiation back and forth, and we fell out there. We all know what happened in the state of Mississippi. There is a strong effort by the Mississippi Medical Association and some of their allies with the FDA to try to ban kratom. They lost on the ban, and they are unwilling to support regulations, which as a medical professional, you would think you'd want to protect people, at least to make sure that the products that are offered for sale in the state of Mississippi would be safer than just the Wild West with unregulated products where we know there is adulteration going on. It was an interesting sidebar. The American Medical Association has a House of Delegates meeting, and for the last 2 years, last year and this year, the Mississippi Medical Association presented a resolution for passage by the American Medical Association House of Delegates. Last year, it was ruled out of turn because they didn't file it properly. This year, they're back, and their proposed resolution was that all kratom products should be banned from over-the-counter sales, that all kratom products should be subject to approval by the FDA before they're allowed for sale. And then they did give us one concession, which is that kratom should not be criminalized in terms of its possession. The House of Delegates recommended changes to the Mississippi Medical Association's resolution and essentially gutted it because it wasn't based on good science. Oh, the other thing they wanted was to make kratom a Schedule III drug. You can't do that under the Controlled Substances Act. So that wasn't even well developed, well researched, or well framed. But these are extremists that are, excuse me, these are extremists in the medical profession that are trying to use the power of the bully pulpit created by their being doctors to try to ram through bad public policy. And they got it shoved to them at the House of Delegates because, frankly, good policy sense prevailed. They could see how radical this position was. So I think that that bodes well for us going forward. I think that some of the other states where we continue to work, we're going to see and bear fruit on them. We did stop bans, and the reason that we stopped the bans, people tell me all the time, oh, well, the AKA comes in and they just spread their disinformation. That's our critics that say that. But the truth is that what we do is talk about the science and the scientific criteria for scheduling of kratom. And you don't have to believe anything that the AKA says. You have to believe the exhaustive review that was done by the Department of Health and Human Services, who is delegated by the Controlled Substances Act to be the arbiter of any recommendation made for scheduling by either the FDA or NIDA. And they determined, it was the Department of Health and Human Services determined that the FDA's evidence and data was disappointingly poor evidence, failing to consider the overall public health. It was the Drug Enforcement Administration who evaluated the FDA's claims in 2016 and rejected them for insufficient evidence. And it was the Expert Committee on Drug Dependence on December 1st of 2021 who said that the FDA was wrong and unanimously agreed that the criteria for scheduling, which is lesser at the International UN Commission on Narcotic Drugs, which would have compelled us to start scheduling proceedings here in the United States because we're a treaty partner, had they passed it. They unanimously agreed that there wasn't the science. So anybody that wants to say, oh, well, the FDA is spreading disinformation and that's what stopped these bans, they're not telling the truth, because what we do is simply lay out the science, and the science reviewed by independent experts are the ones who make that decision. And so that's why we defeated the bans in Mississippi, in Louisiana, in West Virginia, in South Carolina, in Montana, and in Georgia. And we're going to continue to defeat those bans because we are going to ask that we follow the science. That's the bottom line. And I know that there are the people in the anti-kratom space that say, oh, that's unfair and all that. No, you follow the science. You can't just will your way through it with the information that you have opinions about the actual scientific evidence about kratom. You have to actually have scientific evidence and data, not opinions. And that's why we prevail in those battles. Now, that's not to say we don't have to point it out, because we know that the FDA is very influential. We have a documented evidence that the FDA has actually attempted to influence state legislators in the review and in the passage of sponsorship and voting for the Kratom Consumer Protection Act. They're not allowed to do that. They're not allowed to put their finger on the scale as a federal agency to lobby a state legislator in that. It is improper and I think arguably illegal. And we're now investigating and researching exactly the specific laws that were broken when FDA officials do that. That is the arrogance of an agency that is now out of control. And by the way, why do they have the resources to go after and call and try to lobby a state legislator when they don't have the time or the resources, apparently, to go after those 75 companies that are illegally marketing kratom with therapeutic claims that are in violation of the Federal Food, Drug, and Cosmetic Act? This smells to high heaven, and they don't have a credible basis to be doing the kinds of things that they're doing. We are active in a number of states still in these legislative sessions. The majority of states are part-time legislatures, and they're wrapped up most of what they're done. But we're still active in New Jersey, which these are all full-time legislatures, Pennsylvania, North Carolina, Ohio, Michigan, Wisconsin, and Massachusetts. I think that when we're done here, we will have moved the needle significantly in those states, and we will get a couple of states, I think, to pass it this year or early next year, because some of them are 2-year cycle states. But everybody I talk to, when they sit down and they get to see the evidence and data, when they get to see the scientific profile of kratom, the addiction liability of kratom as evaluated by scientists, they say, I get it. I get it that the FDA is off the rails. But more importantly, when they hear the messages of people that say Kratom has improved my life. It saved my life. That's what makes a difference. And I think that the combination of good science and the personal testimonials of people that are using Kratom, that aren't abusing it, that aren't taking it improperly, then I think that that's what wins the day in these kind of situations. So to wrap this up in terms of where we are with the Kratom Consumer Protection Act, over the last couple of years, the resistance that we get, to the extent that there is resistance at the state level, really comes from the regulators saying we don't want to or don't have the wherewithal, the experience, or the resources in order to regulate Kratom. So we've adopted a different model for the KCPA so that it reduces the burden on the state regulatory agencies. It makes certain, to the extent that it's possible to do so, that it doesn't burden the taxpayers of those states. We impose the cost of the regulations on the Kratom processors and retailers who benefit financially from being able to sell those products. And we, of course, want to make sure that those products, when they're offered for sale in the state, that they are properly manufactured, that they pass GMP standards, that they're tested, and that they meet the purity standards, so that they're not either adulterated or synthesized, and they have labeling that gives safe direction. There's no question that the industry needs to mature in this area. We need to have tougher labeling. We need to make sure that people are able to read and understand the guidance on an individual product, to know what the serving size is, what the number of servings are in the container of the Kratom product they're purchasing, and how many servings they should take in a day. That's necessary advice, and we're going to continue to work to improve our position on this in order to educate the processors and the consumers so that they know how to safely use Kratom. So with that, I'll stop and we'll open it up for any questions that anyone might have along the way. So Ryan, I'll turn it back to you to go over the questions.
That's great. Thank you, Mac. And from Jeff, is the Indonesian trade still being hindered? If so, is it on our end or their end?
So this is a complex question, because we had been hearing reports that there are containers that are being shipped that are empty, or that only have a very small quantity of Kratom when they arrive in the United States. And so that there was a thought that maybe there's been something going on at the port where the product's being seized and very little gets through. The conflict is that we're now hearing there may be some scamming going on, where there are containers being shipped that never had any Kratom in them at all. And so we're obviously going to watch that develop. We have been working with the Indonesian government for now going almost 3 years to encourage them to adopt a set of standards that will assure that any Kratom that is exported from Indonesia would be tested prior to shipment, that it would be certified with an independent testing laboratory authorized by the government, and then it would enter the shipping supply chain, and then it would be tested when it gets here to the United States, all as a precursor to go to the FDA and challenge their import alert. We are getting closer to an agreement with a ministry in the Indonesian government to be a partner with the AKA to challenge the import alert. But the good news in all of that is that they now are focusing on how they can make certain that there is no Kratom that's contaminated being shipped out of Indonesia. And they've got the standards now in place. We work cooperatively with them to identify the supply chain so that you go back to the source of the farm where the Kratom is being harvested and processed all the way to port. Those are important safety protections for the people in the United States who are Kratom consumers, and frankly, globally. So we're going to continue to work with that. We've been invited to come back to Indonesia in July, and we're taking a delegation there, and hopefully we'll finalize some of these discussions and get to a formal petition to the Food and Drug Administration to lift their import alert, which will standardize the Kratom shipping routes and protect the farmers, because then there could be legitimate commodity trading practices instituted and not put the farmers at such risk. So we're going to continue to work on that. We can't do much about the fraud that's going on to the extent that it's existing, other than a more cooperation at the Indonesian level when it's shipped, that they make sure those containers are actually containing the full shipment of Kratom that's being contracted for. and no gamesmanship is being done. There is also the possibility that something is happening in transit, where they're always shipped through another port, and whether the Indonesian shipments are legitimate, they get to a transshipment port, and that the kratom is being heisted there and then being sold through the black market. Who knows? But we're going to continue to help explore that, and we're relying upon the vendors to really protect that supply chain going forward.
Thank you. And it's a good question. How do you keep your cool when a legislator hasn't even read the bill that's on the docket, let alone research it?
Well, my training is, I've been married for almost 46 years now. And so I've been trained to keep my cool as best I can. It's frustrating when you hear a legislator make a statement, and by virtue of the question or statement he made, he hasn't even read our bill. That's frustrating. But my job is to speak for you. And it's not about my personal emotional response, but rather about making sure that we convey as best we can what the science says and what the good public policy is. And I think even for a legislator that's wrong, they deserve our respect. And it's just an educational process. There are a couple of legislators that have infuriated me. There's no question about that. There is I won't name him, but there is a legislator in Louisiana that stunned me with the disingenuous way he would tell me, and we would shake hands on a deal, and then he would go do exactly the opposite. That was surprising to me because I think your word has to mean something. But I chalk that up to an experience by that individual, and I think that we'll eventually get to a point, even though there's a little tension there, that we'll get on side with the right public policy in Louisiana in this next legislative session. So that's all I can do. And I can tell you, I go home and I punch my pillow, because it can be very frustrating when you hear some of these legislators say the incredibly unresponsive things that have nothing to do with the truth. Now, some of them are just reading right from the FDA website or the Mayo Clinic website, which just repeats what the FDA says. But we're getting the upper hand on this, because the more we talk about it, the more opportunities we have to talk about the true science, the better off we are. And part of this is that we're learning too. There is information that's coming out now, that current information that has appropriately modified beliefs that we had back in 2016. A great example of that is 7-hydroxymetrogenate. We believed in 2016, based on the available science at the time, that was an alkaloid of the kratom plant. It is not. It is a metabolite of it. It's a metabolite that occurs after harvest, and it's not completely clear as to the impact of the drying process, or whether it's just once it gets out in the air, whether it's drying or not. There's a change in it, but the metabolite structure of 7-hydroxymetrogenate forced us to reevaluate our position on it and properly characterize it as a metabolite, and that changes the way in the recommendations we make in the Kratom Consumer Protection Act as to the levels of 7-hydroxymetrogenate. We believe that 2% was the right level before. Anything above that clearly was adulterated. We now know that level's lower, and it's 1% is what we're recommending now. New science is coming in that may indicate that it's even less than that. And the importance of that level is very simple, that if a kratom product is tested and it has a 7-hydroxy level that's higher than whatever the limit is in that state, in this case, we're advocating for 1%, but let's say it goes to 0.5% next year, anything above that is clearly adulterated or synthesized to a point at which it would be harmful for the consumer. So that's an example of how we can learn from it. Now, I know that some of our detractors will say, "Oh, well, see, the AK was wrong," and you know what? I'll admit it. There are times when we have to modify our positions based on what the science tells us, and I hope that those detractors will come to the table and also admit that some of their outrageous statements about the toxic levels of kratom can be modified too by the science. And I hope at some point we can get together and join forces to do the one thing that I think, the one common thing we all share, and that is to make sure that when a kratom product is available in the marketplace, that it is a safe product. and that it's properly labeled and it's properly regulated so that we don't have these circumstances where you get an adulterated product that leads to an outrageous addiction and leads to deaths. And we know that that's happening. I will never forget the experience that I had in Ohio in the Senate Health Committee last year, when, as we finished our testimony on the Kratom Consumer Protection Act, the next bill up was a bill that discussed legalizing fentanyl test strips. And the first speaker, the first witness, was Dr. Weinstock. And I didn't know her from Adam, and I was just slowly getting out of the room with some of our advocates. And she said to the health committee, she said, "You need to pass the Kratom Consumer Protection Act." She goes, "I'm not here they didn't come here to talk about that, but you need to do it because my son died of a Kratom overdose." And I stopped cold, and I turned around and listened to her. She said, "My son went to American University in Washington, D.C., and he and his friends would use Kratom in order to help them get through, to increase their focus and energy to get through late night studying sessions." She said, "My son went out and bought Kratom on the street that was laced with fentanyl, and he died of an overdose of an adulterated Kratom product." Now that's tragic, but that illustrates the problem that we have in the 9 deaths in Sweden, adulterated with low-dose tramadol. The deaths that we have reported, that if they're examined carefully, and if their testing is applied to it that's necessary, as proven by the Centers for Disease Control on the 91 deaths that they detected Kratom to be a part of the tox screen, as reported by medical examiners and coroners, that those 91 deaths, 7 were Kratom only. That was what the conclusion of the medical examiners was. And when the CDC then applied more sophisticated analytical tools that would not necessarily have been available to the medical examiners, because they're very expensive pieces of equipment, and for the blood samples of the 4 of the 7 that were available, all 4 were polydrug use. All 4. Now, I'm not suggesting that when these families talk about their family member passing away and they say, "Oh, my kid wasn't using anything else," I'm not disputing that. I'm disputing the results of a medical examiner or coroner using equipment that doesn't properly evaluate the actual substances that are involved. And we saw it with proof, with evidence in the CDC report. And we know that even of those 4 of the 7 that had blood samples available for testing, that all of them were polydrug use. So those are adulterated Kratom products. That you don't have to be ingesting a product and Kratom and then taking 10 other drugs. You can take Kratom alone that's adulterated with a fentanyl or morphine or heroin or cocaine, any of those substances, at a level that would kill you. And that's the reality that we simply have to come to. And that's, I think, where we're headed to with the science. So I think that I'm looking forward to the day when we can come to that common agreement that science should rule this public policy, not the emotions and not the opinions of people that are well-intentioned but wrong. And we need to get to that point where we can get good public policy that comes from it.
Thank you, Mac. And do you believe the Board of Pharmacy in Nevada will attempt to schedule Kratom this year now that the enhanced KCPA was vetoed?
So this is an interesting question, because the last conversation I had with the executive secretary of the Board of Pharmacy was that he assured me that if the legislature did not interfere with their ability to do so, that they would commence scheduling procedures on Kratom after the legislative session. So we're going to watch very closely what they do. Now, the bill passed, the enhanced KCPA passed with 2/3 of the legislative, both in the Senate and the House. That's a pretty strong signal. And I think that the important element here is that if the Board of Pharmacy in Nevada were to commence scheduling procedures, we'll of course have the hearing, participate in the hearing. We'll go through litigation with them if necessary. But ultimately, if they do issue a scheduling order, it has to be approved by the Legislative Commission in Nevada. And that Legislative Commission is comprised of 12 Nevada legislators who would have to determine whether or not the action taken by the Board of Pharmacy met the criteria, the scientific criteria for scheduling. And I think I like our odds in that decision. And I think that that's going to be where we'll get safety in that procedure, because you can you can get a crusader who believes that the FDA is wrong, and there's no one that's worse on this than that staff at the Nevada Board of Pharmacy, because they were unreasonable. They didn't care about the science. It was clear they didn't. Everything we gave them, they ignored and said it didn't matter to them. And they're going to have to now justify it before 12 legislators who are not going to be bamboozled by that nonsense and aren't going to be cowed by the power they have. They have the power to do what they're going to do, but the legislature has the power to slap them down. And I think that's ultimately what would happen, even if we get to the point. Now, they may in a moment of common sense say, you know what, we're not going to get anywhere with it anyway. And so they'll just pass on scheduling it. That will unfold here shortly, but we'll see.
And from Brennan, I want to personally thank Mr. Mack, Mr. Ryan, and Mr. Curtis for all the work you've done in Louisiana. It was a pleasure to meet you in person, Mack. Has there been any word on SB 94 after it was amended to reflect the KCPA in Louisiana? If you can just update us again there.
Well, unfortunately, what we ended up with was just an age ban and then a restatement of the obvious, which is that the local parishes can continue to have more restrictive or whatever kratom policy they want to have. So for the next year, we're going to have to educate local parishes about why banning kratom would be a terrible public policy. We'll get a couple that'll probably ban it because the sheriffs down there are pushing hard on it, but we'll be back next year. And I think that there was some misinformation that was circulated about the governor's position on kratom in the last day of the session that thwarted our ability to get the KCPA enforcement sections added to it. So we're going to be back in Louisiana fighting. I am very grateful to the advocates that showed up because your message moved people. We had a ban bill that got approved by the House, and then the KCPA bill got approved with a much larger margin and ultimately passed the House of Representatives, and the ban bill got thrown to the side. That's because of the advocates. And I couldn't have been prouder to stand shoulder to shoulder with them when they gave their testimony and supported the right public policy with respect to kratom.
That's perfect. And from Chris Kratom, is there a direction to look for proof supporting the Deshay Act for us as a group? For us as a group can scour for information, example, looking for import records via U.S. territory.
So we've been at this battle for a long time and haven't found anything yet that's actionable with specific information about the importation of kratom into the United States for the purposes of commerce. We're working with some top-notch people in the Hmong population where it's been repeated often that they were using kratom just after the Vietnam War in the United States. The threshold for proof is difficult because the FDA requires that you have a sales slip from a software system that can be validated. Well, there were no such systems in the small mom and pop delis that were selling kratom prior to 1994. That was reserved for the big box chains, and we know that it doesn't have it there. So we're looking to explore to find records. One interesting thing that we might be able to do is look at the shipping companies that were involved in the shipping from Indonesia to the United States prior to 1994 and see if any of them have any records in their archives that would document that kratom was being brought in, because it was I think it was in 2005 that a court case opened the public records for the Customs Bureau to allow for shipments to be disclosed. But prior to that, they were protected, and we just need to find a way around that. So we're going to continue to work on finding evidence that supports our theory that kratom was, well, things we know, but it's theoretical right now without the absolute proof that kratom was in commerce. Where the emphasis on this has now led to a lot of people saying, hey, I've got a lead, and they're continuing to work on it. So we're looking forward to that, and we're going to continue to work on it.
Excellent. And our final question, Macca, is there proof of Weinstock's claim about her son's death?
Yes, she's a medical doctor. She has the records, the autopsy, with respect to her son, and she knows that the product was adulterated with fentanyl. So yes, I mean, she stated it under oath in a hearing. She is a medical professional, and I get it that it's not the narrative that a critic of Kratom wants to hear, that someone says that their son died of a Kratom overdose that was adulterated with fentanyl. That reality is tough for a parent, but it was an adulterated Kratom product. It wasn't that her son was taking fentanyl and then Kratom at the same time, and that's the fact of the matter.
That's great, Mac. And I'm not seeing any further questions. Would you like to have the closing comments?
So I think that all of us have been through this battle since 2016, and here we are, 2023, and we have had miraculous success in staving off any ban and being able to have the science be the determining factor in any of these scheduling decisions, either at the federal or the state level, and for that matter, the international level. Had we not had our voices at the table, those bans would have taken place, because there wouldn't have been sufficient emphasis or activity that documented to these policymakers that they needed to look closely at it. Because most people, and it's just a natural thing, if the FDA says it, then by God, it must be true. And I'm telling you that the policymakers are waking up. The reputation of the FDA on Capitol Hill today in Washington, D.C. is pretty lousy. And so I think that the truth can prevail despite the information and the disinformation and the misleading information that the FDA is circulating about Kratom. And their actions when they could be regulating this product and protecting consumers show that they don't give a damn about protecting people. They just want to get to their regulatory objective along the way. The science and the scientists are against them. The policymakers are against them, and that's why it's not regulated today. And at the end of the day, it's because of this community. We have a real challenge. The FDA's back at social media harvesting of data that they can try to build a case against Kratom. They're trying to influence individual state legislators who are promoting the Kratom Consumer Protection Act that I believe is illegal, and we're going to dig into that. Certainly inappropriate and unethical for them to do it. We're going to continue to confront the onslaught of information from respected research organizations like the Mayo Clinic, because they don't have the good sense the Lord gave them when it comes to determining independently whether the FDA is right or not. They just accept the FDA's word on this, and we're going to have to continue to fight that, counter it, and we do that with good science, with a strong voice, unified together. We've got to continue to do it. And when you look at what's happening right now in the landscape across America, you have these shark trial attorneys, ambulance chasers who are out there hustling cases, exploiting families to make them believe that Kratom killed them. And you look at the evidence behind that, and all those trial attorneys are doing is looking for a payday for themselves. They collect a ton of money in those cases, and when they can build class action suits, they get mega bucks, and that's what they're about. And that's why you get an offer by some group of trial attorneys to fund with $1 million the anti-Kratom groups. We have to match that, not dollar for dollar. We have to have $10 for every one they do, because they are being funded with the sleaziest of money, with trial attorneys who have one motivation, and it's not good public policy. It's not to protect the American public. It's to get to the bank as quick as they can with settlements by forcing Kratom companies to settle with them rather than go through the enormous costs of litigation. I see that more and more. It's undermining the fabric of the judicial system, but it's what they're allowed to do, and they do it well. They're formidable opponents. So we need to be up there fighting every way we can, and you see what the challenges are. We've got to fight these improper arrests of people, where Kratom is used as a pretext for the arrest. We've got to fight in Washington, D.C. to get good legislation that prevents the FDA from their crusade against Kratom. And we've got to fight at the state and local levels to make sure that we do everything we can to protect the right of an American to make informed choices about products that they use for their health and well-being. And that is something that's protected under the First Amendment by the Constitution of the United States. You can't tell me that because the FDA has an opinion about Kratom that they get to enforce it on an individual, and they can't complain that people are sitting in their homes self-medicating with Kratom. Now, they can complain if the reason they're doing it is because some Kratom manufacturer has told them that this Kratom can help them with their opioid or alcohol addictions. They can certainly go after those companies, but they shouldn't come into the homes of Americans who are making informed choices about what they want to do, because that's a protected right. And if the FDA were serious, if they were really doing their job, they'd be going after those 75 plus companies that we have already reported to them, and not a single prosecution. That is infuriating that they would think that they could get away with that with any kind of credibility. And why Dr. Califf allows it to happen, I'll never know. He testified before the Congress that he knew that one of the great frustrations that he had when he left the FDA, when he was there as the FDA commissioner, I think it was under Obama, and came back years later and said there hadn't been one single ounce of progress that had been made on CBD or Kratom regulations, and that he needed additional statutory authorities. They've produced the statutory authorities they need for CBD. At least they've articulated the framework for them. Have they said a word about what they need to regulate Kratom? They've not. They've not. This is the crusade of lies that they think that they can win on, and use the bully pulpit they have and the bully tactics and the army of regulators, and we have to stand up to them. And if we don't, we'll lose. So as long as we get the support from the Kratom community, we're going to be in there. We're going to be in there fighting hard in order to protect the Americans' right to make those choices on their own, informed choices, good regulations, responsible regulations to go forward. We need your help. That's the bottom line. And I hope everybody will reinvigorate themselves and don't rely on others. Don't say, I'm tired. Oh, somebody else will take care of this for us. No one else will be there. And there have been a couple of hearings where it's been disappointing to see the few that stand up. We need everyone to be available. And I know it's a sacrifice, but do what you can to be there. So thank you to everyone that does that. And thanks for listening to that diatribe. Obviously, it's something that is near and dear to my heart, that we need to continue this fight.
Well, that's perfect, Mac. Thank you, as always. Thank you all for joining us this evening. We will be in touch in the coming weeks with the latest updates again. And please reach out directly if you ever have any questions or need to discuss what's going on in your area. So thank you.
Can I add one more thing, Ryan? I should have said this. If everyone would look in your state where there has been a vote on a Kratom Consumer Protection Act, and we know that those states are out there, and take a moment to find the legislators, both the sponsors of our bill and those who supported it, and go on their Facebook page and say thank you. If nothing else, say thank you, because they are defending freedom, and they're standing up for the rights of Americans to have those very freedoms that I just talked about, and we can't do it without them. So take a moment to go onto their Facebook pages, go find them and say thank you. Nothing else. You don't have to make the arguments about Kratom, because that battle will be taken up in the next legislative session. But say thank you to them, because they need to know that this community is unified and that we appreciate the efforts they do. So I'll leave it at that. Thank you, Ryan.
No, thank you. And thank you all, and have a great evening.